Morning, ladies and gentlemen. I'd like to welcome you to County Court at Law Number 2. My name is Judge Terrence Holmes. I'm presiding judge here in County Court at Law Number 2. This morning, we have what is called an arraignment, and the arraignment is basically an opportunity for the court to tell you what you've been charged with, what your rights are, and what your options are concerning your case. Now, the case that you have in this court is a criminal case. Criminal cases are divided into felonies or misdemeanors. Your felony cases are referred to as your more serious type offenses, whereas your misdemeanor cases are normally referred to as your petty offenses. It does not mean that they're not serious. It just means that they're not as serious as a felony offense. And when I use the term serious, what I'm talking about is the facts of the case and the possible punishment that a person can receive if they are convicted of the offense. Now, felony cases are divided into 5 categories, and we'll start at the top and work our way on down to the bottom. You have the capital murder, first-degree felony, second-degree felony, third-degree felony, and the state jail felony. If a person is convicted of a state jail felony, the range of punishment is minimum 2 years to a minimum 6 months to a maximum of 2 years in the state penitentiary, and a fine that does not exceed $10,000. If they are convicted of a third-degree felony, the range of punishment is minimum 2 years to a maximum of 10 years in the state penitentiary, and a fine that does not exceed $10,000. If a person is convicted of a second-degree felony, the range of punishment is minimum 2 years to a maximum of 20 years in the state penitentiary, and a fine that does not exceed $10,000. If a person is convicted of a first-degree felony, the range of punishment is minimum 5 years to a maximum of 99 years to life in the state penitentiary, and a fine that does not exceed $10,000. If a person is convicted of a capital murder, which is the highest felony offense, the range of punishment is minimum life in the state penitentiary without the possibility of parole or death by lethal injection. Now, the offense that you have been charged with is classified as a misdemeanor, so you don't have to worry about the punishments that I've just mentioned. Now, misdemeanors are divided into 3 categories, and we'll start at the top and work our way on down to the bottom. You have the Class A misdemeanor, the Class B misdemeanor, and Class C misdemeanor. Now, the Class C misdemeanors are cases that start in the JP court or the city court. They come to this court when a person is convicted in the JP court or the city court, and they appeal their case. And then with a Class C misdemeanor, the range of punishment is by fine only, and the fine cannot exceed $500. So if a person is convicted, you can't give them jail time, you only can give them a fine. However, if they fail to pay the fine, or if the fine was converted to community service and they fail to perform the community service, then the court can issue what is called a capias pro fine. It simply means that it's a warrant for the person's arrest for them to either pay the fine or for them to sit the fine out in jail. And if they sit the fine out in jail, they will receive $100 credit for every day that they sit in jail, and that credit will go toward payment of their fine and court costs. Now, the next highest misdemeanor is a Class B misdemeanor. And the range of punishment for a Class B misdemeanor is minimum 0 days to a maximum 180 days, which is 6 months in the county jail, or a fine that does not exceed $2,000, or they can be given both such fine and confinement. The next highest, or the highest misdemeanor, is a Class A misdemeanor. And the range of punishment for a Class A misdemeanor is minimum 0 days to a maximum of 365 days, which is a year in the county jail, or a fine that does not exceed $4,000, or they can be given both such fine and confinement. Now, you may be eligible for probation. There are 2 types of probation that you can receive. One type of probation is called unadjudicated probation. Unadjudicated probation. The other type of probation is called adjudicated probation. Now, the difference between the two is as follows. With adjudicated probation, you will have a conviction on your record. However, if you successfully complete the probation, then the court has the discretion to set aside the conviction by what is called judicial clemency. Now, in order to qualify for judicial clemency, three things has to happen. One, you have to successfully complete the probation. Two, there cannot be any more time left on your probation. And three, you have to be successfully discharged from the probation. If those three things happen, then the court can set aside your conviction. That is, you will no longer have a conviction. However, if you get another conviction later on, we call that a subsequent conviction. Then if you get a subsequent conviction, then the case that you received judicial clemency on can be brought back up. It can be brought back up, resurrected or revived, and used against you. And if you try to get a license with Child Protective Services, which is CPS, they can deny giving you a license, or if you have a license, they can suspend or revoke that license. The other type of probation, as I mentioned earlier, is called unadjudicated probation. With the unadjudicated probation, you will not have a conviction on your record. So, and if you successfully complete that probation, the case will be dismissed, and you may qualify for what we call a non-disclosure. And what a non-disclosure is, it just basically means that your record will be sealed to the general public. That is, we cannot disclose the fact that you were on unadjudicated probation to the general public. So notice I use the term general public. That simply means that most of the public cannot have access to it. However, the government and certain governmental agencies can have access to it, but most of the public cannot have access to it if you get a non-disclosure. Now, as a defendant in a criminal case, you have rights. And I'm gonna go over a couple of rights that you have as a defendant in a criminal case. The paperwork that you have on that clipboard, I'm getting ready to go over that paperwork with you right now. So the first document on that clipboard should be titled, Judge's Explanation of Rights to Defendants Without Attorney. And that document states, as a defendant in a criminal case, you have three options regarding your right to have an attorney. Number one, you may hire your attorney. Number two, if you want an attorney but you do not have enough money to hire an attorney, you may request that an attorney be appointed to represent you. And number three, you may represent yourself. That is, if you waive or give up the right to have an attorney. Now, if you want an attorney to represent you and you have enough money to hire an attorney, your case will be reset. Reset means that you'll be given another court date to give you time to hire an attorney. Now, if you want an attorney, but you do not have enough money to hire an attorney, you can request that an attorney be appointed to represent you. But you must first fill out a financial questionnaire. The financial questionnaire is a document, it's a 3-page document that's titled Jefferson County Affidavit of Indigence. That's the document that's also on the clipboard. I'll go over that document with you in a few minutes. Now, if you want to waive your right to have an attorney, that is, give up your right to have an attorney and represent yourself, you would have to first sign a written waiver of your right. Written waiver is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. That is also a document that's on that clipboard. Now, you should be aware that there are dangers and disadvantages of self-representation. Waiving your right for an attorney and representing yourself may result in a worse outcome for you, including your case. It also may result in the loss of significant rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. Now, if you choose to waive your right to have an attorney, you would like to represent yourself, you may change your mind at any time and request that an attorney be appointed to represent you. Now, if you waive your right to have an attorney to represent you, you'll have an opportunity to talk to one of the three prosecutors that's sitting at that table. The prosecutors are assistant criminal district attorneys that work for the Jefferson County District Attorney's Office. You can talk to them about settling your case. We call that a plea bargain if you represent yourself. Now, if you have an attorney representing you, your attorney will have the option that, to talk to the prosecutors. Okay. Now, at the bottom of that document, the first document, judge's explanation of rights to defendants without an attorney, you'll notice at the bottom there's 5 lines to the left. If your choice is to hire your own attorney, then you will place your initials on the first line to the left. If you've already hired an attorney to represent you in your case, you'll place your initials on the second line to the left and the name of the attorney on the line to the right. If your choice is to request a court-appointed attorney, then you will place your initials on the third line to the left. If you have already been appointed a court-appointed attorney to represent you, then you'll place your initials on the fourth line to the left and the name of the attorney on the line to the right. If your choice is to waive your right to an attorney, that is, you want to waive your right to an attorney and represent yourself, and you would like to represent yourself, you'll place your initials on the fifth line to the left. Now, once you finish initially one of the 5 lines, then you will sign your name on the line that is titled defendant, and you would date it today's date, October 8th of 2024. Now, everyone should sign that page. Now, if you place your initials on the first line, stating that the first 2 lines, stating that you want to hire an attorney or you have already hired an attorney, that's the only document you need to sign. Okay, you don't need to sign anything else. Now, if you place your initials on the third line or the fourth line, well, if you place your initials on the third line, saying you would like to apply for a court-appointed attorney, then you would have to go to the document that is titled Jefferson County Affidavit of Indigence. Okay? And on that document, you're going to start where it says this portion to be completed by or with defendant. And then you're going to place your name, your middle initial, last name, date of birth, then your address, apartment number, city, state, and zip code. Then the next line, phone numbers, your home, cell, work, or family member. And then when you get to the next line, it says, I receive. Now, if you receive Medicaid, you'll check that box. If you receive SSI, you check that box. If you receive SNAP, check that box. If you receive TANF, check that box. If you have public housing, check that box. Now, if you do not have any of those things, you want to check it. And it says, are you employed? If you are employed, you check yes. And it says, if not, you check no. Now, for those of you who check yes, it says, if yes, where are you employed? You say where you employed, your type of employment. The next line says, how many hours per week do you work? How long have you worked at this job? And then the next line asks you for your marital status. You'll check the box. If you're single, you'll check that box. If you're married, check that box. If you're divorced, you'll check that box. If you're widowed, check that box. Or if you're separated, you'll check that box. And then if you're married, you have to write your spouse's first name, middle initial, and last name. And then the next line asks for name of dependent. That's children 18 years old or younger. 18 years old or younger. You'll write their name and their ages in the appropriate space. Now, when it says the next line is residence information. Now, if you rent a home, you check yes. If you own a home, yes. Or if you reside with a family member, yes. Or if you're homeless, yes. So you'll check whichever box is appropriate for you. Now, at the bottom on the left-hand side, it says monthly income and assets. Monthly means what you make a month. So if you says my take-home pay is whatever, that's a month. Now, if you do not work, it'll be zero. Spouse's take-home pay, if you have a spouse, you write their take-home pay a month. If not, zero. Child support, receive. If you receive child support, whatever you receive a month, if not, zero. SNAP, food stamps, whatever you receive a month, if you don't receive food stamps, zero. Social Security, disability, if you receive Social Security disability, you write that amount. If you don't receive it, it's zero. Other government work, other government check. So if you receive some type of government check, you place that amount. If you do not, zero. Other income, if you have another job or another source of income, you place that on. If not, zero. Assets, if you own a car, house, etc., you just kind of estimate what the value is. And they say total monthly income, and assets, you just add up everything in that column that you just filled out. Now we'll go to the right side of this document at the bottom. It says monthly expenses. What is your rent or your mortgage a month? If you have that. If you do not have that, it's zero. What is utilities? Electric, gas, water per month. If not, zero. Total child expenses, including child support paid. So if you have a child or children and you're taking care of the child or children, what that expense is, and if you're paying child support in addition, you'll add those with the other expenses that you're paying. And if not, you don't have any children, you don't have any children, it's zero. Total food expenses, that's for the household. That's per month. Transportation costs. When we look at transportation costs, what we're talking about is your average amount that you're paying for gas, your car note, and your insurance. You add that up per month and place it in that column. Now, if you have a home or cell phone or both, whatever that bill is a month, you put it in that column. If you're paying probation fees, parole fees, or paying a bondsman, whatever that fee is a month, you place that in that column. And then where it says medical expenses, health insurance, if you have it, if you don't, if you have it, you place that amount. If you don't, it's zero. Minimum credit card expense. If you have a credit card and you have to pay a minimum monthly amount, you place that there. If not, it's zero. And then you total up everything in that column. And then we'll go to the next page where it says defendant's oath. You place the day's date, which is the 8th of October, 2024. You read that statement, sign your name where it says defendant's signature and date. And then you'll go down the unsworn declaration by defendant. And you fill that information out. It says my first name, middle name, last name, my date of birth is, my address is, and it says country, USA, and where it says executed in Jefferson County, state of Texas on the 8th day of October 2024. And then you'll stop right there. You won't have to do anything else because everything else will be for the court to fill out. Okay, now that's for people who are requesting a court-appointed attorney. Now, if you are not requesting a court-appointed attorney and you are waiving your right to an attorney, then only people who are waiving their right to an attorney will have to read and sign the document that is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. So if you hire an attorney, you don't have to sign that document. If you are asking for a court-appointed attorney, you do not have to sign this document. Only the people who will be waiving their right to attorney, that is, they'll be representing themselves. That's the only people that would have to read and sign this document that I'm getting ready to go over. And the document is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. Now, if you are hiring an attorney, once you finish filling out that first document, you stop. If you are requesting a court-appointed attorney, you fill out the first document and the second document, which is the affidavit that I just went over, and then you stop. And so if those are individuals who will be representing themselves, you fill out the first document. Now you would have to fill out this document, the waiver of counsel for purposes of entering a guilty plea or proceeding to trial. And it states as follows: I have been advised of the nature and charges against me and the dangers and disadvantages of self-representation. My waiver is voluntarily, which means that nobody's forcing me to do it, and intelligently, meaning that I know what I'm doing. So it says my waiver is voluntarily and intelligently made. Furthermore, I have been advised this 8th day of October of 2024 by County Court at Law Number 2 of my right to representation by counsel in the case pending against me. I have been further advised that if I'm unable to afford counsel, one will be appointed for me free of charge, understanding my right to have counsel appointed for me free of charge. If I'm not financially able to employ counsel, I wish to waive that right and request the court to proceed with my case without an attorney being appointed for me. I hereby waive my right to counsel. And if a waive means that I'm giving up my right to counsel, I'm representing myself. And if that is your choice, you will sign your name on the line that's titled defendant, and you will date it today's date. Now, as a defendant in a criminal case, you also have a right to have a trial by jury. Those 12 chairs behind the bailiff, we call that area the jury box. 6 citizens from Jefferson County will be selected to serve as jurors in your case. And as jurors, they will listen to all the evidence, they will listen to all the arguments, they will deliberate, and then they will decide whether to find you not guilty or guilty of your charge. Now, as a defendant in a criminal case, you have a right to waive or give up your right to have a trial by jury. So in essence, you have a right not to have a trial by jury. Now, if you waive your right to have a trial by jury, your case will come before the court in one of 3 ways. One way it can come before the court is by way of a bench trial. And a bench trial is a trial by judge only. The judge will be the judge and the jury. The judge will listen to all of the evidence, listen to all the arguments. The judge will apply the facts to the law, or the law to the facts in this case, and then the judge will decide whether or not to find you not guilty or guilty. Now, the other way that your case can come before the court is by way of an agreed plea bargain. Now, plea bargain, as I mentioned earlier, is an agreement that you work out with the state to settle your case. Now, if you have an agreed plea bargain, that means that you and the state have reached a settlement on your case, and then your case can come before the judge. The judge can do one of 2 things. The judge can either accept the plea bargain agreement that you reached or reject the plea bargain agreement. Now, if the judge rejects the plea bargain agreement, you have the right to withdraw or take your plea back. So, for example, if you and the state have worked out a plea bargain agreement for you to serve 1 day in jail, and then the judge, it comes before the judge says, well, I'm not going to follow that plea bargain agreement. You say, well, judge, if you're not following the plea bargain agreement that I've reached with the state, I take my plea back. You have a right to do that if the judge does not follow your plea bargain agreement. Now, if the judge does follow your plea bargain agreement and you decide within 30 days that you would like to appeal your case because you believe, 1, that you've been wrongfully convicted, or 2, that the court committed an error by convicting you, then you have to get permission from the judge to appeal your case. And the judge gives you permission, then your case will leave this court and it will go to the 9th Court of Appeals, which is right above us on the 3rd floor. And the judges in the 9th Court of Appeals will review your case to see whether or not you've been wrongfully convicted or whether or not this court committed an error by convicting you. They can do one of two things. They can grant or deny your appeal. If they grant your appeal, they can just simply find you not guilty. Case is over. Or they can send the case back down to this court and order this court to give you a whole new trial. Now, if they deny your appeal, then you can appeal it to a higher court than the Ninth Court of Appeal. You can appeal it to the highest criminal court in the state of Texas, which is called the Texas Court of Criminal Appeals, located in Austin, Texas. You would have to file what is called a pro se petition for discretionary review. Pro se means that you are representing yourself. You do not have a lawyer representing you. And you would have to file this pro se petition, petitioning the Texas Court of Criminal Appeals to review your case. Now, they can do one or two things. They can grant or deny your pro se petition. If they grant your pro se petition, they can just simply find you not guilty, case is over. Or they can send the case back to the Ninth Court of Appeals with orders, or they can send it back down to this court, ordering this court to give you a whole new trial. Now, if the Ninth Court of Appeals deny your pro se petition for discretionary review, then your conviction will stand. Okay. Now, as a defendant in a criminal case, you also have a right. I mentioned that you have a right to have a trial by jury. If you waive your right to have a trial by jury, you can have a bench trial, or you can have an agreed plea bargain with the state. Now, if you in the state have been unable to reach a plea bargain agreement, that's called an unagreed plea bargain. That means that you still want to plead guilty or no contest, and you want the judge or the court to decide what your punishment will be. Okay? And so if you enter into an unagreed plea bargain agreement, it comes before the judge. The judge can set your punishment anywhere within the punishment range. So for example, you have a class B misdemeanor, the court can give you anywhere from 0 days to 180 days in the county jail, a fine up to $2,000, or the judge can give you deferred probation or unadjudicated probation or adjudicated probation. All right. Now, the next thing, the other right that you have a right to have witnesses to come to court. They sit in that chair over there where the microphone and the chair is. We call that the witness stand. And what witnesses do, they can testify for you or against you. If you're representing yourself, you can ask them questions. If you have an attorney representing you, they can ask them, your attorney can ask them questions. We call that either direct examination or cross-examination. Now, you also can waive or give up your right to have witnesses. What that means is you have a right not to call any witnesses in your case. That does not mean that the state will not be calling witnesses in the case, because they will be calling witnesses in the case. Now, if you also have a right, and we call that a Fifth Amendment right against self-incrimination. I know a lot of times we see a lot of these series on television about Law and Order and these other series, and you might hear a person, the police come up to them and they say, well, they want to ask you a question. They say, I take the fifth. What they're saying is, I'm exercising my Fifth Amendment right against self-incrimination. I have a right not to say anything. You can't make me say anything, and so I'm not saying anything, basically. And so with your Fifth Amendment right against self-incrimination, the state, the government, the district attorney's office cannot force you to take the witness stand and testify against yourself if you exercise or invoke your Fifth Amendment right against self-incrimination. Now, you can waive or give up your Fifth Amendment right against self-incrimination. If you do so, then you will be taking a witness stand. Now, you also have a right for discovery. Discovery means you have a right to see the evidence that the state has and that they will be using against you. That is, you have a right to see witness statements, your statements, police reports, lab reports, photos, video recordings, you have a right to listen to audio recordings. You have a right to see any type of documents that they have that they'll be using in your case. You also have the right to have access to any instruments that they also will be using in their case. Now, you also have a right to waive or give up your right to have discovery. If you waive or give up your right to have discovery, then you will not be having access to the evidence that the state has. Okay. Now, everyone that's here today for court, you were arrested, you was placed in jail, and you're out of jail on bond. You're either out on a cash bond, which means you pay the full amount of the cash to get out of jail. You're out on surety bond, which means you only pay a percentage of the bond to get out of jail, or you're out of jail on what we call a PR or a personal recognizance bond. Now, every day that you spent in jail, that jail time can be used as credit towards your punishment. So for example, now notice I said every day. Let's say you went in jail, you were booked in the jail at 11:59 p.m. at night. You bonded out at 12:01 a.m. 2 minutes later, right? That's 2 days. That's 2 different days. And so you get credit for 2 days being in jail, even though you were in jail 2 minutes. Okay? So now every day that you spent in jail can be used as credit toward your fine and court costs and toward your punishment. So let's say you're in the state that worked out a plea bargain agreement, you spent 5 days in jail, the state is offering that you serve 5 days in jail. That means you won't have to serve any more time in jail. Why? Because you've already served 5 days in jail. Therefore, you'll be given credit for the time that you've already served. Now, if the district attorney's office is offering 7 days in jail, you serve 5 days in jail, that means you only have to serve 2 days in jail because we'll subtract 5 from 7, that leaves 2. Now, every day that you spent in jail also can be used as credit toward your fine and court costs. You will be credited $100 per day for every day that you spent in jail that will go toward your fine and court costs. So if you spent 5 days in jail, that's $500 credit that will be credited toward your fine and court costs. So if the state is offering you a fine and court cost of $500, that means you won't have to pay anything. Why? Because the 5 days that you spent in jail has already paid it off, and therefore the fine and court costs will be what we call taxed and retired. It's already paid. Now, if the state is offering fine and court costs of $700 and you spent 5 days in jail, which is $500, that means you only have to pay $200 because you already have $500. We'll take the 500 from the 7, that leaves 2. You'll be required to pay that $200 on balance on the day that you dispose of your case. Now, if you cannot pay the balance on the day that you dispose your case, no problem, because we can put you on what is called a payment plan, where you can pay off the balance so much each month until it's paid off. Now, for some people, they may not have the income to pay off the balance at all because they don't have the income. No problem. The court can convert your fine and court costs to community service. You will receive $12.50 credit toward every 1 hour of community service that you perform in a nonprofit organization. So in our scenario, if you owe $200, that just simply means if you work 8 hours one day, that's $100. You work another 8 hours the next day, that's $200. So 2 days, 8 hours a day, that paid off your $200 balance of fine and court costs. Okay. Now, if anybody has a phone, you need to take your phone, turn your phones off. Okay. Now, next, Jefferson County has a program that is called pretrial diversion. That program is for, when I say Jefferson County, I'm talking about the district attorney's office. That program is for people who have never been in trouble before. This is the first time being in trouble, first case or cases. Then what they will do is they will dismiss your case and you can get it expunged from your record. Okay, this is how it works. Once you get into the program, they dismiss the case. Once you complete the program, you can get it expunged from your record. Now, expunged means you can get it erased, deleted, or wiped off from your criminal history. which means it's like it never happened. It's not there. In order to qualify, it has to be first time getting into trouble. It cannot be an offense for unlawfully carrying a weapon or resisting arrest. And two, it has to be, you have to have an attorney to assist you at getting into the program. And again, if you get into the program, they'll dismiss the case and you could get it erased, deleted, or wiped off from the record. Now, if you are a veteran of any one of the branches of the United States military, the Jefferson County District Attorney's Office also has a program that is called Veterans Court. This is a program for veterans only. And what they will do in the Veterans Court, if you get into the Veterans Court program and complete the program, they will dismiss your case and you may qualify for a non-disclosure. Okay? That simply means your record will be sealed to the general public, as I mentioned earlier. So if you're a veteran of any one of the branches of the United States military, you may qualify for Veterans Court. Okay. Now this court has a program that is called the CSI. We call it the CSI program, which stands for Community Safety Initiative. It is a program that I started within the first 100 days of taking office in March of 2017, which was 7 years ago. Through this program is designed to address the issue of recidivism. Recidivism, which means where people commit crimes over and over. And so we address it through partnerships that we have in the community. And one of the partnerships that we have in the community is with Spindletop Center. Spindletop is our local mental health center in the Southeast Texas region. Now, Spindletop has the expertise to address mental health needs. Spindletop, what they will do is today, they can do a private interview, either in our jury room, or they can do an interview at their facilities, or if you prefer to have the interview by phone, they can do it by phone. They also have the ability to do what is called an assessment. And they also have the ability, once the assessment is done, to either refer you for either outpatient or inpatient treatment, depending on what your mental health needs are. Now, you do not have to be incompetent or insane to participate in the program. You can just merely suffer from depression or anxiety or any other host of mental illnesses, and they will be able to address your mental health needs. Spindletop also has a program, it's a drug and alcohol recovery program that is called ATAR, ATARs, which is an acronym that stands for Addiction, Treatment, and Recovery. And we also have a partnership with our local drug and alcohol council that has a recovery program that is called OSAR, OSAR, which stands for Outreach, Screening, Assessment, and Referral. Both of those programs are drug and alcohol recovery programs to address issues that individuals may have with drugs or alcohol. They will do a screening, an assessment, and then a referral for either outpatient or inpatient treatment. The other program that we have in place is called, with other partnership that we have with the Golden Triangle Empowerment Center. Now, the Golden Triangle Empowerment Center has a partnership with Lamar University. Lamar University has a program that is called CICE. It's an acronym that stands for Center for Innovation, Commercialization, and Entrepreneurship. It is a job training and a job placement program in the hotel industry, the shipping industry, or the chemical industry. Once you are trained in one of those areas, they will assist you at getting a job in the area that you're trained in. Now, if you have not graduated from high school, you do not have a GED, the CICE program also has a GED program where you can get your graduate equivalency diploma. Now, all of these programs that I have just mentioned to you are free. It does not cost you anything but time. And I like to say in this court, we do not just give time, we take out time. That is, we do not just arrest the problem, we address the problem. And we believe that if we address the problem, we can produce productive people. If we produce productive people will not commit crimes. Why? Because they have too much to lose. And so I say that when you come to county court at law number 2, we do not have court as usual. We have unusual court. It's not because we're different, but it's because we're trying to make a difference in the lives of the individuals that come before this court. And if we make a difference in their life, we will make a difference in their home. And if we make a difference in their home, we will make a difference in the community, because what comes out of a home goes into the community. And so that's why we have our community safety initiative. Now, if you're interested in any one of these programs, just let us know. And as I mentioned, not only the program is free, but all of these programs that I just mentioned can also be used as community service towards your punishment. So for example, let's say you were ordered to pay a fine and you could not pay the fine. And we converted the fine to community service. And as a consequence of converting the fine to community service, you decide, hey, you know what? I think I might get into the Spindletop program, or I might get into the job training program or the GED program, or I just might get into the alcohol recovery program. Any one of those programs that you get into, every 1 hour that you spend in that program, $12.50 will be going toward paying your fine. You'll be also in the program. So it doesn't cost you anything, as I mentioned, but time. And the other thing is, you will not only be killing 2 birds with 1 stone, it's 3 birds. You're in the program, doing community service, and you paying your fine and court costs, all by doing one thing. So if you're interested in the program, just let us know, and we'll be happy to give you the brochures and point you to the people that you need to talk to in this program. Now, at this time, we have some folks with Spindletop who's going to come and tell you a little bit more about the program that Spindletop has to offer. We have Deputy Hinton and Lori. They're going to come before you and tell you more. Okay, Deputy Hinton and Lori.
Thank you, Your Honor.
You are.
Good morning. My name is Steve Hinton. I'm a mental health deputy licensed by the state commission here with the sheriff's department. I'm here with my co-worker, Lauren. Lauren is a mental health professional. The reason we are both here this morning in this courtroom is the judge here. What the judge has found, what statistics prove, is those who have legal issues commonly have mental health needs, use disorders, but sometimes just a lack of community resources to help you with your particular situation.
Morning, everyone. My name is Lori Chapman. I am a mental health professional for the Spindletop Center. We're a mental health services provider, but that's not all we do. We do a variety of other services and connect you to things that you may need to address the issues going on within your own life. And if you'd like to talk about those things with someone who can connect you to those resources, we'd like you to let us know.
Now, maybe this is your first time to be in court. It could be your 5th time to be in court. There's still hope. In fact, what we're offering you today has the ability to change your life. We're going to need something from you. We're going to need you to share that need with us. And already explain exactly how you can do that very private.
In a moment, when the court goes in recess, we'll pass out these forms. And if you need something from us, or you just have some questions, fill out the information and hand it back to one of us. And we'll reach out to you within the next week. If you can't think of anything that you need right now, keep this form with you because it has our numbers, our contact information on the bottom. And if something comes up later, you'll have our information and you can reach out to us anytime you like.
I also have this card that I want to give everyone before you leave here today. It's the first resource we can actually give you. It has a 1-800 number on there. Should you ever find yourself in an unsafe place, you can call that number and get help immediately. And just shortly, the court is gonna go into recess, and when it does, we'll be able to come out there, we'll visit with you, we'll get these documents to you, we'll answer any questions you have. I'll also be handing this out to everyone at that time as well.
Thanks everyone for your time.
Thank you.
Okay. Thank you, Deputy Hinton and Laurie. Okay, ladies and gentlemen, the court is getting ready to go into recess in a few minutes. And before we do that, I need to give you some instructions. The paperwork that you have on the clipboard, we're going to pick that paperwork up from you. And then we're going to call you up before the bench, one person at a time. And then once you finish here, you'll go to the court coordinator and she'll give you the instructions of what you need to do. Now, it's gonna take us a few minutes to pick up the paperwork and then go through the paperwork. And so if anyone needs to use the restroom, there's some restrooms out in the hallway. The men's restroom is in front of County Court Law number 3. And the female restroom or the women's restroom is on the opposite side of the hall in front of the 172nd District Court. Now, do not leave the courthouse. If you leave the courthouse and your name is called, you do not answer, a warrant can be issued for your arrest. If you need any help with filling the paperwork out, we have our court personnel who's here, who will be happy to help you or assist you at filling the paperwork out. Again, the court is going to go into recess, and if you need some help with the paperwork, just raise your hand and they'll be happy to help you with filling the paperwork out. Also, the folks from Spindletop is going to come out and visit with you during the period of recess. So at this time, the court is going to go into recess. Mr. Denby on Zoom?
Yes, sir.
Okay, Mr. Denby, your case is gonna be reset to October 25th. You need to be in court in person because you have to come in and sign the paperwork.
Okay. Could you reset it a little bit further?
Now that's October the 25th. That's the
I'm
date.
s- I'm supposed to go to rehab next week. Um, at Unity. I'm just waiting on a bed to get in there.
Well, so you say you waited. Okay, do you know what date?
No, sir. She just told me that it should be next week. I have to call her every day to
Okay,
see if
what
they
we're gonna
have a
do?
bed opened up. And
Yeah.
did you speak at a church in Port Arthur
Yes, I did.
recently? I
Now,
was there.
okay, that's good. Now, Mr.
Yes, sir.
Denby, you need to, we're gonna reset your case. We're gonna try to reset you before you go into, to the rehab. We're gonna, reset it for Monday. And if you're there, you need to, call and let us know,
Yes, sir.
okay?
Okay, thank you.
All right, so we're gonna
Mm.
set it for Monday. What's that date? The 14th. All right, you have a blessed day.
Yes, sir. You too. Thank you.
All right, and, we hope that you're successful in your recovery.
Thank you, sir.
All right, you have a blessed day.
You too. Bye bye.
Jefferson County Court at Law number 2 is back in session with the arraignment docket. First case is cause number 24 CCCR 1692. The case is styled the state of Texas versus Rachel Leanne Park. Ms. Park, is that your full name?
Yes, sir.
Ms. Park, would you please raise your right hand? Ms. Park, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth so help you God?
Yes.
Ms. Park, you may put your hand down. How are you doing, Ms. Park?
Okay.
Okay, you can relax. You don't have to be, I know you're a
I've
little
never done
nervous.
this before.
I understand.
Okay.
I know you're a little nervous, but just, you can relax. Now, Ms. Park, the state is represented in this case by Attorney Haley Simmons. Attorney Simmons, how are you doing?
I'm great, Judge. How are you?
I'm doing fine. Thanks for asking. Now, Ms. Park, before we get started, you have a right to have a record of this proceedings. Do you waive your right to have a record made of this
Yes.
proceedings? Okay. Ms. Park. I have before me two documents on paper. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes.
And are these your initials on the line that state you'd like to waive your right to attorney and represent yourself?
Yeah.
I also have another document that is titled Waiver of Counsel for purposes of entering a guilty plea or proceeding to trial. Do you recognize this document? And is this your signature on the line that's titled Defendant?
Yes.
Okay. Ms. Park, I have a document on my computer that is titled Information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Rachel Leanne Park, on or about May 23rd of 2024, while you were in Jefferson County, Texas, that you committed the Class B misdemeanor offense of reckless driving. Ms. Park, do you understand what you have been charged with?
Yes.
And to this charge, Ms. Park, how do you plead? Guilty, not guilty, or no contest?
No contest, Your Honor.
Now, are you pleading no contest freely and voluntarily?
Yes, sir.
And are you pleading no contest because you do not wish to fight or contest the charges? Okay. Ms. Park, I also have before me on my computer tablet a document that is titled Misdemeanor Plea Admonishment. This document is also labeled as State's Exhibit number 1. Now, Ms. Park, let me do this here. Cannot exceed 30 days. Okay, now, Ms. Park, I'm gonna put my initials here. I have a document. This document is titled Misdemeanor Plea Admonishment. It's also labeled as State's Exhibit number 1. There's one box that's checked in this document, and there's the box that's checked states that this is a Class B misdemeanor. And I'm gonna tell you what the range of punishment is for a reckless driving Class B misdemeanor, which is different from an average Class B misdemeanor. And the range of punishment, the confinement in jail for a term not to exceed 30 days, a fine not to exceed $200, or both such fine and confinement. Do you understand the range of punishment for a Class B reckless driving?
Yes.
On page 2 of this same document, there are 2 sets of initials. One set of initials below a paragraph that's titled Waivers, and it is on a line next to a box that's checked Nola Contendere, which means no contest. Did you place your initials RP on this line? The second set of initials is below a paragraph that is titled Discovery Admonishment. And the initials are on a line next to a statement that reads as follows. I do not request discovery of the evidence. I waive my right to request discovery in this case and choose to enter a plea of guilty or no contest. Do you understand that statement?
Yes, sir.
On page 3 of this same document, there's a signature above the line that is titled defendant. Is this your signature?
Mm.
And on the next document that's titled trial court certification of defendant's right of appeal, do you recognize this document?
Mm.
And is this your signature on the line that's titled defendant?
Mm.
At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement?
Yes.
The second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement? Now, Ms. Park, before you signed and initial all of the documents that I showed you, did you read the documents? Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Ms. Park, are you a citizen of the United States? State?
For states one.
Ms. Park, the state is offering state's exhibit number 1 to be used as evidence against you in your case. State's exhibit number 1 is the first document that I showed you on this tablet, the one where I made the marks about 30 days with the range of punishment being 30 days confinement and a fine that does not exceed $200. This is the same document that have your initials in these 2 locations and your signature on page 3. The state would like to use this document as evidence in your case. Do you have any objections to the state using this document as evidence in your case?
No, sir.
No objections. State's exhibit number 1 will be admitted. Ms. Park, is there any evidence that you are currently mentally incompetent to stand trial?
No, sir.
Okay, Ms. Park, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do, Your Honor.
And what is the agreement?
In exchange for defendant's plea, the state's offering 6 months deferred probation, $200 fine, 30 hours community service, anger management plus court costs.
What is our court cost?
Sorry.
Okay, Ms. Park. The state is offering that you serve 6 months deferred adjudicated probation. During the 6-month probationary period, you will be required to pay a fine of $200 plus court costs of $330. You'll be required to pay a probation fee of $60 a month, reanalysis fee of $15 a month, reimbursement fee of $15. Your total monthly installments, that is the total amount that you will be required to pay each month while you're on probation, is $199 a month. Will you be able to pay the $199 each month?
Yes, sir, I believe so.
And you will also be required to perform 30 hours community service and attend and complete an anger management class. And you also be required to adhere to the standard terms and conditions of this probation. Ms. Park, do you understand the state's offer?
Yes, sir.
Do you think that the state's offer is fair and just?
Yes, sir.
Do you accept the state's offer?
I do.
Okay, now, Ms. Park, if you successfully complete this probationary period, this case will be dismissed. It would not result in a conviction on your record. and you may qualify for non-disclosure. You can talk to an attorney about the non-disclosure.
Yes.
Now, Ms. Park, this will conclude your case. You're gonna stand in front of the court coordinator, follow the directions of the bailiff. Once you finish following the directions of the bailiff, you're free to go and you have a blessed day.
I appreciate your time. Steve.
Thank you. Victor Rodriguez Dominguez. This is cause number 24 CCCR 1542, case is style of the state of Texas versus Victor Rodriguez Dominguez. Mr. Rodriguez Dominguez, is that your full name, Victor Rodriguez Dominguez? Would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? You may put your hand down. Mr. Rodriguez Dominguez, how are you doing? You doing all right? That's good. Now, Mr. Rodriguez Dominguez, I have before me on paper 2 documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document? Is this your signature on the line as titled defendant? Are these your initials on a line that state you like to waive your right to an attorney and represent yourself? I also have another document that is titled Waiver of Counsel for purposes of entering a guilty plea. Do you recognize this document? And is this your signature on the line that's titled defendant? Now, Mr. Rodriguez Dominguez, on this computer, I have a document that is titled, well, first of all, before we get started, I have before me, attorney, Kyle Gasper. She's with the district attorney's office. You understand that?
Mhm.
And also, did I ask you whether or not you wanted to waive your right to a record in this case?
You said that.
Okay, so you want to waive your right to a record in this case?
I don't understand that.
You have a right to have somebody to type down.
Oh,
Okay, so you want to waive or give up your right to a record?
no,
Okay. Now, Mr. Rodriguez Dominguez, I have before me on this computer a document that is titled Information. This is a document that was filed by the Jefferson County District Attorney's Office charging you with the offense of driving while intoxicated. Okay. In this document, it states that you, Victor Rodriguez Dominguez, on or about February 13th of 2024, while you were operating a motor vehicle in a public place in Jefferson County, Texas, that you committed the Class A misdemeanor offense of driving while intoxicated with an alcohol concentration level of 0.15 or more. Do you understand what you have been charged with?
Yeah.
Now, to this charge, Mr. Rodriguez Dominguez, how do you plead? Guilty, not guilty, or no contest?
okay.
Now, are you pleading no contest freely and voluntarily? And are you pleading no contest because you do not wish to fight or contest the charges? Mr. Rodriguez Dominguez, I also have before me on this tablet a document that is titled this misdemeanor admonishments. Okay, misdemeanor plea admonishments. Do you recognize this document?
Yeah.
On page 2 of the same document, there are 2 sets of initials. The first set of initials is below a paragraph that is titled waiver, and it is on a line next to a box that's checked nola contendere, which means no contest. Did you place your initials right here? The next set of initials is below a paragraph that is titled discovery admonishments, and the initials are next to a statement that reads as follows. I do not request discovery of the evidence. I waive my right to request discovery in this case, and I choose to enter a plea of guilty or no contest. Did you place your initials in this document? On page 3 of this same document, there's a signature above the line that is titled defendant. Is this your signature? Now, Mr. Rodriguez Dominguez, before you sign, hold a minute. I got one more document I forgot. Now, the next document is titled Trial Court Certification of Defendant's Right of Appeal. Do you recognize this document? And is this your signature on the line that's titled defendant? At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement? The second box that's checked states that you are waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement? Now, Mr. Rodriguez Dominguez, before you sign and initial all of these documents that I just showed you, did you read the documents?
Yes.
Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge?
Yes.
And Mr. Dominguez Rodriguez, are you a citizen of the United States?
Yes.
State offers states one.
Now, Mr. Dominguez Rodriguez, the state is offering State's Exhibit number 1 to be used as evidence in your case. State's Exhibit number 1 is the first document that I showed you on this tablet. This is the same document that have your initials in these 2 locations and your signature on page 3. Is it all right for the state to use this document as evidence in your case? Okay. No objection. State's Exhibit number 1 will be admitted. Mr. Dominguez Rodriguez, is there any evidence that you're currently mentally incompetent to stand trial? None? Okay. Mr. Rodriguez Dominguez, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. This thing is going out. I'm gonna need another. I will also find that this, your waivers was freely and voluntarily given. I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
Yes, we do, Your Honor.
And what is that agreement?
In exchange for defendant's plea, state is offering 180 days probated over 15 months, $750 fine, 80 hours of community service, DWI first standard conditions of probation, interlock, and court costs.
What's the court cost in this case? Okay, Mr. Rodriguez Dominguez. The state is offering that you serve 180 days in the Jefferson County Jail. However, you would not have to serve any time in the Jefferson County Jail because you'll be placed on probation for 15 months. During the 15-month probationary period, you'll be required to pay a fine of $750 plus court costs of $377. You'll also be required to pay the $100 DWI conviction fine. You will also be required to pay a probation fee of $6,000 a month, a urinalysis fee of $15 a month, reimbursement fee of $15. Your total monthly installments, that is the total amount that you will be required to pay each month while you're on probation, is $169 a month. Will you be able to pay the $169 a month? Okay. You will also be required to perform 80 hours of community service. You'll be required to install the interlock device on any vehicle that you want to operate. Attend and complete a DWI education class. You'll also be required to have a drug and alcohol assessment. You'll be required to pay Jefferson County DWI initial evaluation fee of $125 on the day of the plea. Should a further evaluation be needed, you'll be required to pay an additional $50. Now, you'll also be required to adhere to the other standard terms and condition of this probation. Now, Mr. Rodriguez Dominguez, do you understand the state's offer? Do you think the state's offer is fair and just?
I want to hear this much, but it's okay.
Huh?
I wanna have a little couple of months left, like
Oh.
a year or something.
Yeah,
You got
okay.
15, I was hoping 12 or so.
Okay.
That's it.
But it's okay?
Yeah.
Okay,
I don't wanna fight no more. I just wanna go through it.
okay. Now, Mr. Do you accept the state's offer? Okay, I'll follow the plea bargain agreement that you've entered into with the state. Mr. Rodriguez, you're gonna stand in front of the court coordinator, follow the directions of the bailiff. Once you're finished following the directions of the bailiff, you'll be free to go, and you have a blessed day. Jeremy Johnson. Okay, Mr. Johnson, your full name is Jeremy Kelly Johnson. Mr. Johnson, would you please raise your right hand? Mr. Johnson, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Johnson, you may put your hand down. How are you doing, Mr. Johnson? How are you doing? That's good. Now, Mr. Johnson, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document? You have to speak up. Is this your signature on the line that's titled defendant? Or are these your initials on the line that state you'd like to apply for court-appointed attorney? I also have another document that is titled Jefferson County Affidavit of Injuries. Do you recognize this document? On page 2 of this same document, there's a signature above the line that's titled defendant. Is this your signature? Now, Mr. Johnson, before you signed and initialed these documents that I just showed you, did you read the documents? Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge? Okay, Mr. Johnson, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney Peter Dahl. Attorney Dahl will be given information to contact you, and you will be given information to contact him. Our court coordinator will give you that information. Once you get the information from the court coordinator, you'll be free to go, and you have a blessed day. But please have a seat in that first chair. Next case is Russell Bean. Mr. Bean, your full name is Russell Thomas Bean. Mr. Bean, would you please raise your right hand? Mr. Bean, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Bean, you may put your hand down. How are you doing, Mr. Bean?
Fine, how you doing?
I'm doing fine, thanks for asking. Mr. Bean, I have before me 2 documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document? And is this your signature on the line that's titled defendant?
Yes, sir.
And are these your initials on the line stating you would like to apply for a court-appointed attorney? I also have another document that is titled Jefferson County Affidavit of Injuries. You recognize this document?
Yes, sir.
And on page 2, there's a signature above the line that is titled defendant signature. Is that your signature?
Yes, sir.
Now, Mr. Bean, before you sign and initial these documents, did you read the documents?
Yes, sir.
Did you understand what you read? Is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Okay, Mr. Bean, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you is Attorney Jobs Cole. Attorney Cole will be given information to contact you, and you will also be given information to contact him. Our court coordinator will give you that information. Once she gives you that information, you're free to go and you have a blessed day. Please have a seat in that second chair on the wall. Terrence Daniels. Mr. Daniels, your full name is Terrence Daniels. Mr. Daniels, please raise your right hand. Mr. Daniels, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Daniels, you may put your hand down. How are you doing, Mr. Daniels? That's good. Mr. Daniels, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document? No, this document is titled Judge's Explanation of Defendants Rights Without Attorney. Do you understand it? You recognize this document? Is this your signature on the line that's titled defendant? Or are these your initials on the line that state you'd like to apply for a court-appointed attorney. I also have another document that's titled Jefferson County Affidavit of Injuries. You recognize this document?
Sure.
On page 2 of this same document, there's a signature above the line that's titled Defendant Signature. Is this your signature? Now, Mr. Daniels, before you sign and initial all these documents that I just showed you, did you read the documents? Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge? Mr. Daniels, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney, and the attorney that will be appointed to represent you in this case is Attorney David Grove. Attorney Grove will be given information to contact you, and you will be given information to contact him. Our court coordinator will give you that information. Once she gives you that information, you'll be free to go, and you have a blessed day. Okay, have a seat in that first chair. Sir, you need to take your hat off. You're in court. Thank you. Next case, Avery Keith Phillips. This is called number 24 CCCR 1484, case of style of state of Texas versus Avery Keith Phillips.
Yes, sir.
Mr. Phillips, is that your full name?
Yes, sir.
Mr. Phillips, do you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Sure.
Mr. Phillips, you may put your hand down. How are you doing, Mr. Phillips?
That's my best.
Can't be better than that. Now, Mr. Phillips, I have before me on paper 2 documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant? Are these your initials on the line that state
sir.
you'd like to apply for a court-appointed attorney?
Yes.
I also have another document that is titled Jefferson County Affidavit of Injuries. You recognize this document?
Yes, sir.
On page 2 of this same document, there's a signature above the line that's titled Defendant Signature. Is this your signature?
Yes, sir.
Now, Mr. Phillips, before you sign and initial these documents, did you read the documents?
I did read it.
Did you understand what you read?
Yes.
And is everything in these documents true and correct to the best of your knowledge?
The best of my knowledge. Yes.
Okay, Mr. Phillips, I read your answers. Based on your answer, you meet the eligibility requirements for the appointment of a court-appointed attorney, and the attorney that will be appointed to represent you in your case is Attorney Benjamin Jeffries. Attorney Jeffries will be given information to contact you, and you will also be given information to contact him. Our court coordinator will give you that information, and once she gives you that information, you'll be free to go, and you have a blessed day. Please have a seat in that third chair on the wall. You're welcome. Matthew Constant Hall. Okay, Mr. Hall, your full name is Matthew Constant Hall?
Yes.
Mr. Hall, would you please raise your right hand? Mr. Hall, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Hall, you may put your hand down. How are you doing, Mr. Hall? Okay, Mr. Hall, I have before me 2 documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes.
Or these your initials online state you'd like to apply for court-appointed attorney?
Yes.
I have another document that is titled Jefferson County Affidavit of Injuries. You recognize this document?
Yes, sir.
And on page 2 of the same document, there's a signature above the line that is titled Defendant Signature. Is this your signature?
Yes.
Now, Mr. Hall, before you sign and initial these documents, did you read the documents? Did you understand what you read?
Yes,
And is everything in these documents true and correct to the best of your knowledge?
yes, sir.
You can slide down to that first chair. And Mr. Paul, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney, and the attorney that will be appointed. Hold on. The attorney that will be appointed to represent you in your case is Attorney Todd LeBlanc. Attorney LeBlanc will be given information to contact you, and you will also be given information to contact him. Our court coordinator will give you that information. But before, and once she gives you that information, you'll be free to go, and you have a blessed day. Please have a seat in that second chair on the wall.
No.
All right, thank you. His name was Paul. And was it Todd LeBlanc?
That's the finish.
Yes.
Actually, next to the appointment, this is the appointment, contact information, which are contact information, if you know what you need. You're welcome, have a good day.
Francis Hetzel. Miss Hetzel, your full name is Francis Hetzel. Ms. Hetzel, would you please raise your right hand? Ms. Hetzel, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Ms. Hetzel, you may put your hand down. How are you doing, Ms. Hetzel? I'm doing fine, thanks for asking. Ms. Hetzel, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without an Attorney. You recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes, sir.
And are these your initials on the line that states you'd like to apply for court-appointed attorney? I also have a document that is titled Affidavit of Indigence. You recognize this document?
Yes, sir.
On page 2 of the same document, there's a set of initials, but there's a signature above the line that's titled Defendant. Is that your signature?
Yes, sir.
Ms. Hetzel, before you sign and initial these documents, did you read the documents? Did you understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Ms. Hetzel, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney, and the attorney that will be appointed to represent you in this case is Attorney Ryan Matuska. Attorney Matuska will be given information to contact you, and you will also be given information to contact him. Court coordinator will give you that information. Once you get that information, you'll be free to go and you have a blessed day. Please have a seat in that second chair on the wall. Willie Hallmark Nash. Mr. Nash, this is cause number 24CCCR 1708. Mr. Nash, your full name is Willie Hallmark Nash. Mr. Nash, would you please raise your right hand? Mr. Nash, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Nash, you may put your hand down. How are you doing, Mr. Nash? Okay, Mr. Nash. I have before me two documents. The first document is titled Judge's Explanation of Rights of Defendants Without Attorney. Is this your signature on the line as titled defendant? And are these your initials on the line state you'd like to apply for court appointed attorney? I also have another document that is titled Jefferson County Affidavit of Injuries. You recognize this document? And on page 2 of the same document, there, the signature above the line that is titled defendant signature, is this your signature? Now, Mr. Nash, before you sign and initial these documents, did you read the documents? Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge? Mr. Nash, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney John Macy. Attorney Macy will be given information to contact you. And you will also be given information to contact him. Court coordinator will give you that information. Once you get that information, you're free to go. And you have a blessed day. Laura Brown. Ms. Brown, your full name is Laura Brown. Laura Denise Brown. Ms. Brown, would you please raise your right hand? Ms. Brown, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God?
Yes, sir.
Ms. Brown, you may put your hand down. How you doing, Ms. Brown? You blessed? That's good. Can't be better than being blessed. Now, Ms. Brown, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document? And is this your signature on the line that's titled defendant?
Yes, sir.
Are these your initials on the line that state you'd like to apply for court-appointed attorney? I also have another document that is titled Jefferson County Affidavit of Injuries. Do you recognize this document?
Yes.
On page 2 of this same document, there's a signature above the line that is titled defendant signature. Is this your signature?
Yes.
Now, Ms. Brown, before you sign and initial these documents, did you read the documents?
Yes.
Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge? Ms. Brown, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney Jennifer DeLodge. Attorney DeLodge will be given information to contact you. You will be given information to contact her. And the court coordinator will give you that information. Once you get that information, you'll be free to go. And you have a blessed day. Okay. Give me those bond conditions. Thank you. Next two cases, cause numbers 24CCCR 1544 and cause number 24CCCR 1545. Both cases are styled the state of Texas versus Brennan Thompson.
Nash.
I need to have this. Mr. Thompson. Let's see. I have two cases. Both cases are style of state of Texas versus Brennan Michael or Michael Thompson. Mr. Thompson, is that your full name? Mr. Thompson, would you please raise your right hand? Mr. Thompson, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Thompson, you may put your hand down. How are you doing, Mr. Thompson? I'm doing fine, thanks for asking. Mr. Thompson, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document? And is this your signature on the line that's titled defendant? Or these your initials on the line that state you'd like to apply for a court-appointed attorney? I also have another document that is titled Jefferson County Affidavit of Images. Do you recognize this document? On page 2 of the same document, there's a signature above the line that is titled defendant's signature. Is this your signature? Now, Mr. Thompson, before you sign and initial these documents that I just showed you, did you read the documents? Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge? Okay, Mr. Thompson, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you is Attorney Mark Faggart. And Attorney Faggart will be given information to contact you, and you will be given information to contact him. Our court coordinator is going to give you that information. Once she gives you that information, you'll be free to go, and you have a blessed day. Now, before we do that, I'm gonna have to wait and give you some bond conditions. Thanks. Now, Mr. Thompson, I'm gonna hand you a document that is titled Standard Bond Conditions in County Court at Law. Number 2, the bailiff is going to hand you these documents. And I'm going to go over these bond conditions with you. And the bond conditions states standard bond conditions in county court at law number 2. And it states that following the return of a criminal information in county court at law number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are ordered subject to the additional conditions. Number 1, the defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition? Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who, A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol and the test indicates the presence of drugs or alcohol in the defendant's body. Do you understand that condition? Now, condition number 3 and condition number 4 does not apply. However, condition number 5 does apply. And condition number 5 states that the defendant is prohibited from possessing a firearm or ammunition unless defendant is a peace officer as defined by section 1.07 Penal Code, actively engaged in employment as a sworn full-time paid employee of a state agency or political subdivision. Do you understand that condition? Okay, now, Mr. Thompson, if you violate any one of these conditions, your bond will be revoked. And if your bond is revoked, the warrant will be issued for your arrest. You'll be arrested and placed in the Jefferson County Jail. Do you understand? Now, Mr. Thompson, please have a seat in that first chair on the wall. Wait for your name to be called. Once your name is called, you can go to the window. And once you go to the window, she give you your paperwork. You're free to go and you have a blessed day. Next case is cause number M324-824, case is style of state of Texas versus Chrislyn Bolton. Ms. Bolton, your full name is Chrislyn Bolton?
Yes, sir.
Bolton, excuse me. Ms. Bolton, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth? So help you God?
Yes, sir.
You can put your hand down. Now, Ms. Bolton, how are you doing?
I'm doing good.
I'm doing fine, thanks for asking. Ms. Bolton, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document? And is this your signature on the line that's titled defendant?
Yes, sir.
Or these your initials on the line that state you'd like to apply for court-appointed attorney?
Yes.
I also have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Yes.
And on page 2 of this same document, there's a signature above the line that's titled defendant signatures. That's your signature.
Yes, sir.
Now, Ms. Bolton, before you sign and initial these documents, did you read the document?
Yes.
Did you understand what you read?
Yes.
And is everything in these documents true and correct to the best of your knowledge?
Yes.
Now, Ms. Bolton, I read your answers. Based on your answers, to meet the eligibility requirements for the appointment of court-appointed attorney. The attorney that will be appointed to represent you in this case is Attorney Jack Lawrence. Attorney Lawrence will be given information to contact you. You will also be given information to contact him. Now, before you get this information, I need to give you some bond conditions. The bailiff is going to hand you a document that is titled Standard Bond Condition in County Court at Law Number 2. And I'm going to go over these bond conditions with you. The document is titled Standard Bond Conditions in County Court at Law Number 2. And it reads as follows. Following return of criminal information in County Court at Law Number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are ordered subject to the additional conditions. Number 1, the defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition?
Yes.
Condition number 2, defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who, A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs or alcohol in the defendant's body. Do you understand that condition?
Yes, sir.
And condition number 3 states, the defendant shall not communicate either directly or indirectly with the alleged victim of the pending offense, and the defendant shall not go near any residence, school, or other location frequented by the alleged victim. Do you understand that condition?
Yes, sir.
Now, condition number 4 does not apply. However, condition number 5 does apply. Condition number 5 states the defendant is prohibited from possessing firearm or ammunition unless the defendant is a peace officer as defined by section 1.07 of the Texas Penal Code, actively engaged in employment as a sworn full-time paid employee of a state agency or political subdivision. Do you understand that condition?
Yes.
Now, Ms. Bolton, if you violate any one of these conditions, your bond can be revoked. And if your bond is revoked, warrant will be issued for your arrest. Warrant issued for your arrest. You'll be arrested and placed in the Jefferson County Jail. Now, you're gonna have a seat in there. Oh, she don't have to sit down? You can go to the windows so they can get you reset. Once you get your reset, you're free to go. And you have a blessed day. Tremonte Duhon. Mr. Duhon, your full name is Tremonte S. Duhon? Again, Mr. Duhon, how are you doing? Okay, now, Mr. Duhon, I have before me two documents. The first document, the judge's explanation of rights to defendants without an attorney. Do you recognize this document? And is this your signature online inside of defendant? And are these your initials online that state you'd like to waive your right to attorney and represent yourself? I also have another document that's titled waiver of counsel for purposes of entering a guilty plea or proceeding in trial. You recognize this document? And is this your signature on the line inside of defendant? Now, Mr. Duhon, before you sign and initial these documents, did you read the documents? Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge? Okay, now, Mr. Duhon, the state states that they have to do some additional investigation, is that correct? Before
Yes,
they
Your
are
Honor.
able to give you an offer?
Yes, Your Honor, we just need a little bit more time to answer some questions on it.
Okay. So your case is gonna be, how much time do y'all need, you know?
30 days.
Okay, give us a reset for 30 days. So your case is gonna be reset, let me see, do I? Okay, yeah, your case is gonna be reset till. Put it a week after that. Let's get that.
November 20.
That's fine. Or the week, yeah,
22nd. The 20.
okay, your case is gonna be reset November 20th. The court coordinator is gonna give you a reset. Once you get your reset, you'll be free to go. And you have a blessed day. All right. There you go. That's it. Okay, well, let's,
We have one in custody that's still what, waiting, felony?
oh, but is that felony this afternoon?
Yes.
Oh, okay, so we don't have anybody until this afternoon. The court will be in recess till 1 o'clock this afternoon. We had any bond forfeitures?
We, not say two or three.
I don't, he's in custody. Laura, I got that she was a foreign attorney. He was on Zoom. That's him, he's been receptive. That's what I say. Um. 20th, I think. Let's see, page 9. Page 10, somebody named Christopher Phillips.
Yes, sir. And page 11.
What you have on that?
He can put Steve in,
Or in another state?
another county.
Oh,
November 20th.
okay,
Christopher Wilson, Travis. And Turner, page 11.
what we have?
Page
Somebody named Turner, Jaquez, Michael.
Yeah, that one.
Turner, notice return.
They already sent it to the address on the registration paperwork. Have a return from it.
So, but you get, okay, but you sent it, so we still can call it, okay. Jefferson County Court at Law number 2 is back in session. The court is in session in cause number 24 CCCR 1664. Case is style of state of Texas versus Jaquez DeMichael Turner. Jaquez Turner was scheduled to be in court this morning at 9 a.m. At or about 9 a.m., the court's bailiff called the name of Jaquez Turner at the courthouse door. Jaquez Turner did not answer. Jaquez Turner has not appeared in court since the court has been in session. The time now is 11:48 a.m. on today's date. Mr. Bailiff, would you please call the name of Jaquez Turner at the courthouse door?
Where's Turner? Turner? I respond, Turner.
Okay, no answer. Jaquez Turner, name was just called again at the courthouse door. Jaquez Turner did not answer. A reasonable time has passed to give Mr. Turner an opportunity to appear in court. Is not appearing in court. State, do you have a motion?
Statements of bond.
Okay, that motion will be granted. Jaquez Turner bond will be forfeited. And a warrant shall be issued for his arrest in cause number 24 CCCR 1664. Ms. Gasper?